we'll go into the nitty-gritty or to the exact issues. First, we'll look at the ongoing, of course, the report of the panel constituted to investigate the activities of the last administration in Kaduna State, which was presided over, of course, by Madam Nasir El-Rufai as the former governor of the state. Of course, during the week, we saw the report which indicted the governor, to have misappropriated the whopping sum of 432 billion naira, which comprised of money borrowed, internal generated revenue, and so on and so forth. That were not utilized for the purpose that they were, meant for, as alleged by the report of the House of Assembly, of course. But then the twist to the matter was that the governor has gone to court, to challenge that probe, citing that his fundamental rights were breached. He was not given fair hearing, and for the court, to render that report null and void. And people are asking, separation of powers, doesn't it come here? Can the court interfere, in the ongoing investigation of another arm of government entirely? So what do you have to say in all of this?
All right, thank you very much. Looking at the matter playing out in Kaduna State, we see a kind of twist. First, it is clear that where there is an allegation of the commission of a crime or fraud, that it needs to be properly investigated, and once there is a prima facie case made that the person who is suspected of committed that crime has done certain things showing that yes, he has questions to answer, then the law enforcement agencies can go ahead, invite him or her, or arrest him or her, and then carry on with further investigation into the matter. In the case of Kaduna State, it was the House of Assembly of Kaduna State that set up ad hoc committee to investigate the 8-year administration of Madam Nasir El-Rufai. The committee sat, took evidences from witnesses, collected some documents, and at the conclusion of the proceedings of the ad hoc committee, the committee made recommendations. The committee recommended that the former governor, El-Rufai, be referred to either EFCC or ICPC for further investigation for allegedly siphoning a whopping sum of 402 billion from the state coffers. They also recommended that the Commissioner for Finance be suspended forthwith. And the basis of the allegations, when you look at their report, is that loans were obtained by that administration without due process being followed. Of course, in this program, Democracy and Rule of Law, it's emphasized that those in power, no matter the level, federal level, state level, local government, must carry out their activities of governance in strict compliance with the law. So, if actions have been taken or loans obtained without due and strict compliance with the procedure laid down for that, then there are questions to be answered by those involved. And that's what they are alleging, that loans were obtained and the proper procedures were not followed. Secondly, the committee also alleged that some of the monies obtained by way of loans were not used for the purposes for which they were meant. For example, a particular loan tagged for a particular project, after the money has been collected, not being used for that project. They also made allegations of money laundering, amongst others. And then what they are saying is that the former governor and some members of his executives should be properly investigated by the law enforcement agencies, the anti-corruption agencies like the EFCC or ICPC. Now, as the House adopted the report from the ad hoc committee and recommended that Nasir El-Rufai be properly investigated, he went to court. Last Wednesday, he filed a fundamental rights application seeking for an order at the Federal High Court in Kaduna State to set aside or nullify the report of the committee. What are the grounds? The ground he claimed his fundamental rights application is that he was denied fair hearing as encapsulated in section 36 of the 1999 Constitution as amended. That the committee did not give him a right to be properly heard or to be heard. He was denied his right to fair hearing. Now, the issues that we need to look at and explain are this one. The subcommittee that was set up by the Kaduna State House of Assembly has the committee the powers under the law to investigate fraud or crime. That's the first thing we might need to look at. And since from the report, it was an investigative panel of inquiry, yes, they've done a report. But like the House of Assembly later, told the whole world that the proper investigation will be carried out by the EFCC or ICPC.
Okay, so before we continue, so if they are saying that proper investigation will be carried out by the enforcement agencies.
Yes.
So the question is that, of course, what did they now do? What was their own role in all of this? Was there an investigation? What was it that they did, or in fact finding?
Yes, what they did, because it is an ad hoc committee which was set up to prove the 8-year administration of Nasir El-Rufai.
Yeah, do they have power to do that in the first place?
Yes, I see. You see, that is the issue that I raised earlier. That issues that has to do with crime has to be people that are properly authorized by law to investigate crime. You recall what played out in the case of Gaba and Unimaid,
yes.
Where some students, embark on violent protest, which generated into burning of properties, arson and murder and so on. At the end of the day, some of the students, the university set up a panel that investigated the matter, and at the end of the day, some of the students were rusticated, they were expelled from the university. So we are, giving punishment that varied depending on what the panel believed was their level of involvement. They went to court, went to High Court, and the matter finally got to Supreme Court. And the Supreme Court said, look, that the panel set up by the university does not have the powers to investigate crime. That arson is crime, murder is crime, and so on. So at the end of the day, the report of that panel was set aside. as long as it touch on crime. Now, what we now need to interrogate is this adult committee that was set up. Was it a mere preliminary report that was meant to be submitted by that committee, which is to say that they just made their preliminary findings and that the matter will still be subject to further investigation by the appropriate authorized agencies, because that looks like what they are actually trying to do. In the case of Gaba University of Maiduguri, the panel that investigated applied sanctions, punishment. In this instant case, that of Kaduna State Assembly, they have not applied sanctions. And all they did was carry out investigations and made a report with recommendations. Recommendations included further investigation by statutory agencies and possible prosecution for abuse of office, corruption, money laundering, amongst others.
Okay, so to say, they have the right, the House of Assembly has the right
to set up a committee to do preliminary investigations.
Past governance.
Yes, provided that committee did not go ahead to pretend or purport to apply sanctions, because they don't have the rights under the powers of the law.
It's very important for us to understand it, because it's not only in Kaduna State. We understand that the River State governor, government, let me not personalize it, the River State government have also decided to constitute a panel, as announced by, of course, the present governor, that he would constitute to probe the activities of the last administration.
Yes.
Now, it's not the state house, this is the governor.
Yes.
So the question everybody is asking is, who has this overlapping power to investigate? The governor, is this the governor can constitute, the House of Assembly can constitute, or there is, can the judiciary also constitute? Because if the lawmaker, if the executive can constitute, the legislatures can constitute, does it also imply that the judiciary in the state can also constitute?
Well, if we look at
and even the citizens.
Yes, if we look at the bedrock of rule of law, the fundamental tenets of rule of law, the principles of rule of law, one of them is supremacy of the law. The law is supreme and is binding on everybody, no matter who that person may be. And the issue of separation of powers. The concept of separation of powers means that powers are separated. Now, if, like you asked now, the judiciary can set up a panel of inquiry, the question will be, after the judiciary has set up a panel of inquiry, and then the panel now reports to the same judiciary now goes ahead to adjudicate on the matter. It might be, trying to violate the principle of, the fair hearing, that you cannot be a judge in your own cause. You cannot be a judge in your own cause. You cannot be the complainant and at the same time be the adjudicator. So in the case of Rivers State, if the government as a body comes up to say, yes, we want to set up a panel of inquiry to investigate the activities of the past administration, there's nothing basically wrong with that. But then they will be veering off the mark if the panel, after their preliminary investigations, goes ahead to, derail into the arena of adjudication, because it is only a properly constituted court or tribunal that can hear matters that has to do with crime and apply sanctions or punishment.
Yeah, because we are asking, this law needs to be properly situated. We are asking because we've seen former governors being investigated, or this kind of panel being set up to investigate activities of past administration. We saw it in Imo State when His Excellency Emeki Hedwa
Yes.
took over. He set up a panel to recover, and they were recovering shops, cars, some items that was supposed to belong to the government that the outgoing governor had appropriated to himself as a result of the panel that was set up to recover the assets.
Yes, you see, it has to first and foremost be clear as to what is the nature of the powers given to any panel of inquiry. There are panels that are purely given administrative powers of inquiry, and they are limited by the powers conferred on them. There are judicial powers of inquiry. Those ones can, look into what the law says vis-a-vis what has been done, and when you have judicial panel of inquiry, it's expected that there be judges or those that are involved in the practice of law in that panel. There are some that just do purely ministerial inquiry, in which case they are not allowed by law if their duties as conferred by the power that set them up is purely ministerial. There are some that are quasi, you understand? It's a kind of hybrid. They can look at it, they can still look at that. So to look at what happened in Imo State, we need to look at what is the enabling instrument given to that panel. Because for a panel to make recommendations and go ahead to apply sanctions or punishment or recovery, it means that that panel may have been authorized so to do. If not, what they did may amount at the end of the day to having exceeded the powers given to them.
Okay, I think that that is clear enough. So let us move on to the issue of fair hearing.
Yes.
Because the issue of fair hearing was particularly mentioned by the former governor.
Yes,
Yeah,
that's
so,
the Rufia.
Yeah. So what is this issue of fair hearing that has become a bone of contention, and the governor is holding tenaciously on to nullify, the recommendation of this panel. Of course, I'm sure the audience will want to understand what this fair hearing is and how it affects this particular matter.
Yes, you see, in every coin, you have two sides. The way I look at the scenario that has played out in Kaduna State, the House of Assembly did set up an ad hoc committee, and the powers of the committee, from what we have seen, has to do with making investigation into the activities of the past administration of Nasir El-Rufai for the past 8 years, 2015 May 29th to 2023 May 29th. And they swung into action. The committee was set up in April, and by 5th of June they submitted a report, and in the report there were recommendations that the governor and some members of his executive be further investigated, meaning that ad hoc committee does not have the powers of final report on the matter, and then moving the case forward to either prosecution and so on, and then did clear recommendations. Now, on the other side of the coin, El-Rufai has come forward to say that he wants their report to be nullified, to be set aside by the Federal High Court on the basis of denial of fair hearing. Now, the question is, at this level, is it proper for him to have gone to set aside the report of the panel? If he is asking the Federal Court to set aside the report and crediting it politically motivated, is it not proper in the circumstances for him to keep his gunpowder and wait for the agency that may, at the end of the day, take up the matter for further investigation. But definitely, whatever the ad hoc committee may have done is, as far as I'm concerned, a preliminary report. By the time the anti-graft agencies step into the matter, and it is not given opportunity to explain, then he can proceed to court to tell the court that he was denied it. Because if you look at it, the ad hoc committee is not a judicial committee, and because of the judicial committee, its recommendations are not final and conclusive. It needed to be, to be used by an anti-graft agency for further investigation. They cannot use the report to prosecute him for now. The report says, let there be further investigation, and then if, as we have made our findings, the anti-graft agency equally makes findings that is in tandem with our report, then charge him to court for abuse of office, for corruption, for money laundering. Now, does he now think that by rushing to the Federal High Court to say, okay, nullify the report, does that now answer the question of the allegations made against him? It does not, as far as I'm concerned.
Yeah.
If his hands are clean, whether EFCC comes in, CPC comes in, they will find nothing against him. But if there are issues as alleged by the ad hoc committee that bordered on one, obtaining loans for a purpose and misappropriating that money, not using it for the very purpose for which it was approved and obtained, and then not following due process in obtaining loans, and then also engaging in money laundering amongst other corruption. Of course, we have heard it said over and over again that one of the cankerworms eating up this society, the fabric of Nigerian society, is corruption. And it's tantamount to corruption to get loan. You say you are going to use the loan for a particular purpose and then apply it for a different purpose. That also negates the rule of law and democratic principles and practices. It's also against the rule of law for a particular office holder, be it the governor or whatever capacity person may be occupying, to go ahead and engage in corrupt practices. So I believe that it's proper for the anti-graft agencies to look into the allegations and the recommendations, carry out discrete investigations, and find out whether actually there are substantial truths in what the ad hoc panel has found out.
Yeah, but Sobra, just a quick one.
Yes.
Given the fact that the character in question in this scene is a political office holder,
yes,
of course, of high repute,
mm-hmm.
and of course, also given the fact that this reports are going to be relied on, to invite the EFCC or other anti-graft agencies,
yes,
to investigate him.
Yes.
It wasn't it administratively proper, given the fundamental nature of fair hearing, mm-hmm. for him to have been invited, to have also, been able to, communicate his own position before this report would have been made public. Well, fundamental right of fair hearing. Shouldn't it be occurred to, given that this report is going, that is what the EFCC will be relying on to investigate him?
Well, I have a different view. My view is this, and that is that what the ad hoc committee did was preliminary investigation or inquiry into the activities of the past administration in Kaduna State for 8 years, from 2015 to 2023.
So the principal character of the administration, so shouldn't he have been invited?
Hold on. Now, we have also said it, advocated it, that the proper procedure in criminal investigations is that if there's a suspicion that a person or group of persons have done some things that amount to crime, you don't start by inviting the person or group of persons concerned. You carry on an independent and discreet investigation first. It is when your investigation reveals that there are certain things that need to be clarified. There are certain things that, are being revealed that involve the person or persons concerned. It's then and only then that you can go ahead, either as a anti-graft agency or law enforcement agency or whatever nomenclature, to invite the person or arrest the person as the case may be. That's what obtains in the Western world, and even in Nigeria here. The Supreme Court has said in 4ME and IGP that you don't just go ahead and apprehend persons accused of having committed one crime or the other. First of all, you carry out investigation, and if there is a prima facie case, a case that on the face of it shows that yes, there are things that need to be explained, it's then and only then that you go ahead and carry out proper investigation. So in this instant case now, in the case of Kaduna State Assembly, what they've done is in clear compliance with the procedure as said by the Supreme Court in me and IGP and other cases, that you just go and apprehend people and then start your investigation. No. The Supreme Court said, first of all, you carry out your investigation. The person concerned may not even be aware. It's after you've gathered your evidence, both documentary and otherwise, you now invite. And of course, you see the way FBI in America and the way they do their own. They may be investigating a person without the person knowing. There was this particular case where a drug baron living in the United States of America and carrying on that illicit drug business. He never knew he was under investigation. Now, the FBI planted a lady. The lady got close to the man, the drug baron, and they got married. They were living together. And in the course of living together, the duty of the lady was to gather evidence that could lead to the arrest and prosecution of the drug baron. At the end of the day, the lady gathered all the evidence the police needed to arrest this man and prosecute him for drug dealings. And it was at the conclusion that it took not just months, but years. The lady gathered all the evidence, submitted, and they burst. The bubble burst. The man was invited, and when they confronted him with evidence, both documentary and otherwise, he had no answer because they've taken time. And that's one of the challenges we have in Nigeria. Because in Nigeria, a person goes to the police station or writes a petition, and the police just wing into action without carrying out preliminary investigation to know actually whether that petition or report was based on malice or for reasons not connected with any crime. And when they now make their findings, they can now invite the person concerned or arrest the person concerned.
Okay. We'll go on the short break now, but when we return, we're also looking from the angle of that this present case has to do with a public figure. Of course, this report has gone ahead to indict him. I've said that he misappropriated this and that. And we're asking, administratively, wasn't he supposed to, of course, the FBI example you gave, they're not going to make all of those findings public.
No.
Yeah, but in this Rufia case, this report has been made public and has been widely read, and he has been indicted to have done that without giving him an opportunity to be heard. Of course, he could claim that this has done irreparable damage to his image, but when we come back, we'll look at it from this angle to see if he has any case in regards to that. So, Barrister Obiome,
yes.
So wouldn't he have, since they knew that they were going to make this report public, they are not going to quietly submit it to the appropriate authority, to carry on from where they start. They are going to make it public for the whole world, to read. And in the report, they've said that he misappropriated funds on roads were not. So there is concrete shouldn't they have given him an opportunity to be heard?
Yes, what I've said earlier is this, that yes, they've done their investigations
And have made it public.
and have made a report.
Public.
Submitted a report to the House and also made recommendations. But that's not the end of the matter. As far as I'm concerned, it's a preliminary report that, tends to indict him and some of his executives. Now, by the time, if it so happens that any of the anti-graft agencies takes over, they are not going to take completely everything in the report. They are still going to start from the onset to carry out proper investigation into those allegations. The documents that will be submitted, they cross-check them and confront El Rufai with those evidences already gathered by
The commission.
yes. Yeah, those documents are always there, because presently they are even asking that the Commissioner for Finance be suspended forthwith, immediately, because the same commissioner that Sammy, the previous 80, is still the present one. They say that because he is one of those indicted in the report, that should be suspended.
That shows the importance of this report. If the report has the capacity, to damage the reputation of a serving minister, shouldn't they be invited? The principle of fair hearing should have been done. Because I'm sure that is what Malam El-Rufai is contesting.
Now, as far as
if the EFCC will want to investigate him, they should not rely on this report. The EFCC, they will go through petition and let the EFCC start afresh.
EFCC or definitely will start afresh. They will not use the report of the ad hoc committee. That one is basic. But what is that as far as the committee is concerned, there's a prima facie case.
So that
warrants further investigation.
So they didn't have any responsibility. Administrative panel does not have the responsibility to invite the parties to hear from them.
El-Rufai has not claimed he was not given an opportunity at all. You understand? Although I've not read the full details of the matter he filed. But you see, the Supreme Court has said in a number of cases that fair hearing is not a magic wand, that once you mention it, the heavens must fall. No. If you are given an opportunity of a hearing and you fail to avail yourself of that opportunity, you cannot claim that your fair hearing right was denied or violated. And in any case, the report of the committee, like I said, is merely an interim report, a preliminary report. It is left for the anti-graft agents that may handle the matter during the day to carry out further investigation from the beginning and then give him all the opportunities that he needs. What I've observed in some cases is that some people, when they're invited by anti-graft agencies or law enforcement agencies, may not want to show up. Instead of going to defend themselves, answer questions put to them, may want to go to court to stop the agency, anti-graft agency or whatever law enforcement agency, from carrying out the report and then further investigation. But the court have said that when a person is invited to make explanations concerning a crime, that it does not amount to violation of the person's fundamental rights, because it's still an inquiry or investigation. It is when the action of the committee or panel has gone to the point of, one, affecting the person's rights or interests without the person having an opportunity to make an explanation. Now, coming to the Commissioner for Finance, I agree with you that ordinarily, since the recommendation touches the Commissioner's immediate suspension, it will be proper for that Commissioner to be invited and heard before suspension. Of course, some panels still suspend a person with pay pending investigation, so that with the person out of that position in office, then the committee or panel that is carrying out investigation will be able to have access to every document, anything that may aid in the investigation concerned. So at this level, I think the greater good of the nation is for the nation to know whether this former governor was actually involved in the allegations leveled against him. And if that be so, then after proper investigation by law enforcement agencies, then let there be prosecution, and that to be done by the courts. So it is not, proper at this level for us to now be, involved in issue of fair hearing, because, like I mentioned earlier,
because we know that other state governors might also want to toe this line. That is why we're trying to excavate all of the legal angles.
Yes,
so,
yes.
So that in further instance, when other government wants to also, take this course of action, they will ensure that they follow all the rules.
Yes,
of
yes.
instituting a panel. So that at the end of the day, the court wouldn't have any reason to strike off all of the hard work the panel has put, in
yes,
place.
Like I said, the proper way to carry out the investigation that has to do with crime or fraud is do your preliminary investigation, get your facts, get your evidence, even sometimes without the knowledge of the person being investigated, because the person knows he may do away with vital evidence that may make it difficult for the investigation to, be properly carried out. Yes, like I said in case of USD, where they do their own is the police will be on the trail of a suspect. Sometimes they may be tapping the telephone conversations of a suspect. They do some things to find out actually if this report has credence enough before subjecting the person to either arrest or interrogation and so on. And that is what the Kaduna State of Assembly, through its adult committee, has done in this case. They first of all done an inquiry and investigation into the activities of the past administration. Then the other side of it is the publicity, the media publicity there, because now they've come up with a report which the papers, and the man has gone to court, the former governor has gone to court to say, look, my rights have been violated, I was not given an opportunity to be heard. But it appears that he has jumped the gun, because the report of that panel is not conclusive.
The wife refused to tarnish his image.
Tarnish his image?
Yes.
Now, in what context? That he embezzled or misappropriated 402 billion. If that report is true, now which one weighs higher in the scale of the rule of law? Is it the citizens of Kaduna State whose 402 billion were misappropriated, embezzled, or laundered? Facilities they are supposed to have, they are denied. Hospitals, medical facilities, and other things, road projects that money may have been meant for were not done. And maybe because the roads were not repaired, there were accidents and people's lives were lost. Medical facilities were not provided. So which ones ranks higher in the scale of the rule of law? You see, in Shakespeare's Julius Caesar, when Brutus was confronted with the issue of the love of his very good friend Caesar, he said that I love Caesar, but I love Rome more, because the interest of Rome as a nation is higher than that of an individual. So if all that we are being told is that his name has been dented, his name has been defamed, and all those things, that is not enough to say, okay, let the report be nullified, let there be no further investigation, because what that will, dive into is that there may have been serious fraud, corruption somewhere, but somebody is going to go to nip it in the bud, to abort it.
Okay, so what is the of course now the report is already out. It has been the panel has concluded their work.
Yes.
The report has been submitted to the Kaduna State House of Assembly.
Yes.
So what will you advise to be the next line of action in compliance with the rule of law?
Yes.
So that if indeed these actions were correct, the proper thing will be done.
Yes, the proper thing to be done in circumstances is for the law enforcement agencies, the anti-graft agencies, maybe the EFCC or RCPC, to be formally informed in writing of these allegations, and for that agency to carry out investigations. The fact that the fundamental rights is spending may not hinder further investigation if it is not one of the prayers in that report. And of course, the issue is, has this the allegations been, are there, evidences to show that something happened? Were there loans obtained that were diverted to other things and not for the project earmarked? Were loans obtained in clear violation of laid down procedure?
Yeah, because the point you just mentioned that based on the fact that the case is already in court, would it not affect the anti-graft agencies not doing their work? Would they still be investigating or carrying out arrest on a case that is pending in court?
Yes, I can answer you that briefly. Now that when a case is in court, whatever other judgment, rulings in that case will only bind the parties to that case. A party who is not a party to a case will not be bound by whatever order or judgment that may come out of that case. The suit filed by Rufia, is against the Kaduna State House of Assembly and the Attorney General of Kaduna State. The FCC is not included in that suit. The ICPC is not included in that suit. They are not made parties to that suit. It does not favor their hands to go ahead on a complaint, either by petition or otherwise, to investigate properly the serious allegations, which 432 billion is a lot of money. I know it will change the fortunes of the people of that state. And if that money is stashed somewhere, of course, the doctrine of tracing will apply. Because equity will say, yes, this money was removed and was diverted to so place. We will trace that money to wherever it may be, in whatever state it may be, and recover it for the benefit of the beneficiaries of that funds.